OWI 5th. You are 33. How do you wish to plead?
Guilty, Your Honor.
Doing great for 10 years. Something triggered this. She's not BSing me on that. I would plead with you to see how creative we can get.
0.269 OWI 5.
She was pretty hammered. Being sober is scary for alcoholics. She volunteers at Hope Lodge, Mayo Clinic, and at Ronald McDonald's house, Adopt a Highway Fund, and Litter Bit Better.
Know that God has a reason for everything, and maybe this is just a part of my story.
I think you've learned your lesson. So as to count 1, the OWI 5, I'm going to sentence you to.
Today, we have a nice lady who has made quite a turnaround and sounds so very contrite until you realize that she was driving drunk with a 0.269 blood alcohol content and that this is her 5th conviction for drunk driving at age 33. The defendant's character witness sings her praises. Her attorney sings her praises. Hell, even Judge Mogen sings her praises. Is all that enough to keep the defendant's can out of the can? Let's roll, nerds.
We will go on the record in the matter 23 CF 55, State of Wisconsin versus Sarah Stady. The state appears through District Attorney Kevin Schmidt in person. We have Sarah Stady in person in custody with counsel Daniel Chapman. We're set here today for a plea and sentencing. The parties have reached an agreement. Mr. Chapman, can you please recite the agreement for the record?
Judge, Ms. Stady will be pleading guilty to the 5th offense OWI charged in the information. The state has agreed to recommend the presumptive minimum 18 months initial confinement, and there is no particular agreement on extended supervision. The state has agreed that Ms. Stady and I can argue for less under the benefit to the community exception under 346.65. But that is the agreement, Judge.
All righty. Okay. And Ms. Stady, that is the agreement that you've reached with the state,
Yes,
and
Your
that is
Honor.
your understanding.
Yes, Your Honor.
So I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes,
Did your attorney go over this document with you?
he did, Your Honor.
Did he go over it with you thoroughly?
Yes.
That is, did he essentially read it word for word?
Yes.
And so you understand everything completely.
Yes.
Now, is that your signature on the second page?
It is, Your Honor.
If you had any questions with regards to something on this document, did you ask your attorney
Yes.
and he explained it to you?
Correct.
So you're pleading guilty to 1 count OWI 5th. You are 33 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. You are not receiving any mental illness or disorder, or you don't have a mental illness or disorder. And you have not had any alcohol, drugs, or medications in the last 24 hours. Is that correct?
Correct, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over with you the mandatory minimum as well as the maximum possible penalties that you could face?
He did.
All right. Now, because you're charged with crimes, you are entitled to constitutional rights. And each of those rights is listed on this document. And I'm going to go over those rights with you because this is a mandatory prison case. And I need to make sure that you thoroughly understand those rights. Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous verdict to a guilty plea, and you would, or not guilty, and you would have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you would be giving up?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Correct. Yes.
Do you understand, with regards to this matter, this OWI 5th that you are pleading guilty to, the state would have to prove on or around March 4th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes.
You understand that the maximum possible penalty here would be up to a $25,000 fine or up to 10 years of incarceration or both. Do you understand that?
Yes.
Do you also understand that there's a mandatory minimum of incarceration? The state or the court must order a minimum of at least 18 months of incarceration. Do you understand that?
Correct.
And do you understand that pursuant to, as your attorney stated, 346.65 paren 2 paren AM 5, that you could argue to the court for a lesser sentence based upon whether or not the community would be harmed and et cetera. Do you understand that?
Yes, Your Honor.
But do you understand the court does not need to follow any of that argument? You understand that?
Yes.
All right. Now, did you go over the criminal complaint with your attorney?
I believe so.
And in particular, there is a section called the probable cause section. Do you remember that?
It's been a while since we went over that.
All right. So he's showing you the criminal complaint right now, in which it does go over what happened that day and why you were charged with these crimes. All right?
Yep.
And so you see that right now.
Yes.
So now, does that refresh your recollection?
Yes.
And for the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant?
Yes.
And this would be your 5th offense.
Yes.
You're pleading guilty to a felony. Do you understand that you would no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in any civil election until or any election until your civil rights are restored?
Yes, Your Honor.
Do you have any questions, at least right now, before I begin and take your plea?
No, I do not, Your Honor.
All right, then as to count 1, OWI 5th, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea is done freely, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to give up your rights. I'll find a factual basis to accept your plea of guilt. Based upon that, I'm going to find you guilty of OWI 5. Count 2 will be dismissed and read in. Count 3 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Before I go to arguments, Ms. Stady, you have somebody who would like to make a character statement on your behalf. Is that correct?
Correct, Your Honor.
All right. Her name is Jennifer Donaldson. Ms. Donaldson, can you please tell me who you are, your relationship to Ms. Stady, and what you would like me to know?
Thank you, Your Honor. My name is Jennifer Donaldson, and I am the owner of Empower Treatment Center in Rochester, Minnesota, also a woman in long-term recovery. I know Sarah through her significant other, Mike Benjamin, and we have been actively involved in this with her since going forward. We were the ones that did the chemical dependency assessment when she was in Olmsted County's custody. And once we do the assessment, we start with them recommendations, we start acting immediately to be able to help and provide whatever services that client needs. At that point, we reached out to a Minnesota Adult and Teen Challenge, which is a short-term program and eventually turns into a long-term program where it can be anywhere from 13 to 14 months long, where they basically are retraining your brain. We discussed it with her, Mr. Benjamin, and my husband as well, who's also in long-term recovery. And it would be a phenomenal program for her to kind of rebuild back her life, but also get some treatment to see what triggered her 10 years ago. And kind of work towards the goals of rebuilding the relationship with her children and having a successful life and being a benefit to the community and being a stable citizen and figuring out what that problem is because obviously, as you're probably aware, and you see a lot of these cases, any kind of addict, it is a DSM-5. It is just like if you had diabetes or cancer. It is a disease. And that is one of the things why I left my corporate America job to get into this industry, is to help people like Sarah. I will tell you, there's very few people that I actually take time away to speak on their behalf in a court of law when we realize there's 100% in on being able to come up with a solution and what they need to do and how they would need to change and live a full life for recovery. We're there 110%. Sarah has proven that to me and my husband, that that's what she wants. We've had many conversations while she's been in custody. I have essentially mentored her. I've worked with a lot of women on that over the past 16 plus years of my recovery journey. And I've worked with a lot of women. And, you know, she's not BSing me on this. I can pretty much read that when someone is, when a client is, and when a client isn't. She's done a lot through her life. And what I'm struggling with, and I understand Minnesota and Wisconsin laws are different. What I'm struggling with is she was doing great for 10 years. Something triggered this. We need to find out what triggered it and what's going on with it. And I believe everyone also has to pay for their crime that they've done. And at the same point, what can we do to help prevent that? And yes, time served. I have 3 DUIs. I sat in jail. I sat in custody. But at the same point, sending someone away for 18 months when she's got 2 young children at home and a phenomenal support system, I don't think is going to help the recovery. I've seen both ways where incarceration has helped. I've seen where people have done the long-term teen challenge program where it's done amazing things. My husband is a graduate. And I'm a single mom too, and it breaks my heart to see what she's done. And I know that she has remorse for it. I know that she wants to better herself. I mean, she's talked to me about trying to figure out a way how to give back to the community with people in recovery. She's like, if I have to do this, Jen, that's fine. She goes, I'm going to better myself. I'm going to do what I need to do. And she goes, when I get out, if I can be back in the recovery community, she goes, can I come work for you? That spoke volumes to me, because I will tell you, getting in this industry, in this field, you have to have a heart and a passion and a soul for it, which I think she does. She wants to be able to tell her story. I think there's better ways of making more people realize that, you know, going down this path isn't the right way. And it's just, Sarah has it in her. She has a fire in her to overcome this. And I would just like to be able to give her the opportunity to not spend as much time behind bars as what the 18-month mandatory. If I would plead with you to see how creative we can get with this and be able to do something, because I do believe she'd be a huge benefit to the community. Just the fact she wants to tell her story. A lot of people don't do that. A lot of addicts don't do that. And it just isn't right. And I'll be honest with you. I had a brother that died from a drunk driver. So it's hard for me to speak on behalf of people that drink and drive, but I did it myself. She does feel remorse. She knows what she could have done. And I've been pretty hard with her. And I don't know. If there's anything we can do to get creative with this, I know she would give back, and I know she would do such amazing things for the recovery community. And I'm sorry, with the epidemic that's going on with addiction, we need people like her telling her story that could potentially change someone else's life. I mean, if she touches one person, that's all that matters. It makes a huge difference. It really does.
Thank you, Ms. Donaldson. All right, now I'm going to turn to Mr. Schmidt for your argument and sentencing recommendation, please.
Sure. My recommendation is going to be 18 months initial confinement, 1 year extended supervision. So Ms. Stotty
Simply
has,
1 year?
yes, Ms. Stotty has a lot of unique characteristics to her that cuts positively and negatively. She doesn't appear to be a person who has much connection to Wisconsin. All of her convictions are in Minnesota. It's the 4 OWIs, it's 2 driving inimical to public safeties. So all of her convictions are driving related, 2 of them not necessarily alcohol related. Even in this case, when she had contact with law enforcement, she said to them, you know, I'm not from Wisconsin, my OWIs are in Minnesota. Ms. Stotty's OWIs occurred, 2 of them in 2010, 1 in 2011, and then the last one in 2013. So they all appeared within a relatively close range, and the last one was 12 years ago. So she hasn't had an OWI in a very long time, which is why the reason I'm recommending a shorter term of ES than I normally would is because of that, and because she's not a Wisconsin resident. I think she's already done a lot of treatment in Minnesota as well. So I think a lot of what she'll be doing will be refresher, relearning things, repicking up techniques that she didn't apply here. The reason why I'm arguing for the 18 months initial confinement, I don't think the court should go higher because of that gap since the last OWI is so immense. The reason I'm arguing for the 18 months in this case, though, is it can be easy to forget why OWI is a crime and why it has such a high penalty. Because whenever we have an OWI where there's nobody who got hit or killed, we have just the offender. So all the information we're hearing is about rehabilitative potential. And that fixes the focus directly on what benefits them. OWI is a crime. It has such a high penalty because it's a high risk crime. It's a crime of risk. That's why the legislature always changes the reckless driving laws in tandem with the OWI laws, because they're both associated with risk. And it's kind of an oddity, I think, personally, in Wisconsin, that someone has an OWI 4 or an OWI 5 or 6, we talk about like 1, 2, 3 years prison. When somebody has an OWI 5 or 6 and they hit someone, it goes way higher. And if they hit someone and kill someone, it goes higher still, because the actual act is the same in all of those. It's the risk. In this case, the risk imposed was pretty high. There are certain blood alcohol concentrations where a person might be, am I intoxicated? Am I just a little buzzed? Am I good to drive? Ms. Stotty was at a 0.269, which is well beyond that. She clearly knew she was intoxicated. You could tell from the statements to the officers. She was pretty hammered. She knew she shouldn't be driving. She mentioned saying, I'm getting arrested to an OWI before they even really arrested her yet on the phone to a significant other. I fully believe, based on what we've seen from her and what we've heard from the character witness, that she has the fire, she has the desire to change. My concern is with the follow through. That's why I think we need the prison and the ES, because we've even seen it just in this case with the missed court appearances. She's already forfeited more money in cash through non-appearances in this case than most people get as the fine for this offense. And I think that demonstrates, the fear of seeing this to fruition. Being sober is scary for people who are alcoholics. And I think she needs that prison and that ES to deal with that. It's fully true that substance abuse, alcoholism is a DSM-5 disorder. OWI is not. Thank you.
Thank you. Before I begin and ask your counsel for argument and his sentencing recommendation, again, I apologize for having to stop Do you understand? And I did ask you or tell you this and ask you this, if you understood that I don't have to follow any argument as to going lower than the mandatory minimum. But do you understand? I don't have to follow any recommendation. Nothing's binding on me. Do you understand that?
Yes, I do, Your Honor.
And do you still wish to proceed?
I do.
Okay, thank you. Mr. Chapman, argument and sentencing recommendation, but do you have an account for her jail credit?
Yes, Your Honor. It is 78 days.
Okay, thank you.
I've got the dates if anyone wants them.
Thank you. And I'm bending over just so you guys know that to get my OWI information, because with OWI 5s, I have to specifically calculate the fines.
Oh, given that it's a prison sentence, they do not count today, so it would be 77 days actually.
Thank you. Argument and sentencing recommendation, please, Mr. Chapman.
Judge, I think the state laid it out perfectly as to why this case calls for 18 months. And Ms. Donaldson addressed the rehabilitative potential. And I know that Ms. Stady is going to address the court and probably address her personal situations in more detail. Specifically, I'm asking the court to consider less than 18 months under a particular statute that actually doesn't call for the court to look at specifically the seriousness of the offense or the rehabilitative potential. I agree that under the seriousness of the offense and the rehabilitative potential, 18 months would be the appropriate sentence. I don't think it calls for more than that 18 months, but under the statute that calls for the exception, it asks the court to look at would the community benefit? So is it in the community's interest that Ms. Stady serve less than 18 months? And would the community be harmed by her serving less than 18 months? So I'm going to focus mostly on those particular two issues. First of all, as to whether the community would be harmed, I don't believe there would be any difference to the community as to whether Ms. Stady serves 18 months or 12 months or something in between. She's not going to be eligible for the earned release program in prison. She may be able to do some sort of treatment in the community, but really the prison is about punishment. That's what she's going away for. And I think the punishment aspect to Ms. Stady and whether she learns her lesson won't make a difference to the community, whether that's 18 or 12. I believe that the 12 would be sufficient, that she is sufficiently punished. As to whether it's in the community's interest, that's a different question. I call the court's attention to the fact that Ms. Stady is educated and well employed. She works as a project manager on building projects, building government buildings, essentially. So she's helped managing people in large projects. She's also not just dealing with this case, but she's also active in her church and volunteer work. She volunteers at Hope Lodge, which is a housing center at Mayo Clinic for cancer patients, and at Ronald McDonald's house doing food preparation. And she's also involved with the Adopt a Highway Fund and Litter Bit Better, which is another program that helps pick up the community, the streets around her. She has 2 children, which I believe the community would be served by having her out to see them. And specifically in reference to the state saying she missed court, not really an excuse, but I would point out that she gave birth to her more recent child in May of last year and then missed court, I believe, in July of last year. So not so much fear of sobriety as it was fear of leaving her 2-month-old newborn child. And there were no additional crimes that led to her coming into police contact. They just showed up at her door one day and said, "Hey, don't you have a warrant?" and brought her over to Wisconsin. I believe that once she gets out, piggybacking on what Ms. Donaldson said, she is a good candidate for treatment, and she will be addressing these concerns, probably at Teen Challenge, when she's eventually released. This case calls for prison, and she's going to go to prison. There is no creative way to avoid that, and I'm not asking that. But I'm just asking the court to recognize that Ms. Stady is a valuable member of the community. She does provide services to the community, both through her employment, her volunteer work, and her parenting duties. And that having her out in the community addressing these benefits to the community 6 months sooner, I believe, is a benefit to the community. If the court believes that the additional punishment is necessary or that it's an additional risk to the community to have her out earlier, then follow the 18th month recommendation, please. But if the court believes the community would benefit to have her out early, I'd ask the court to consider that.
All right, thank you. Ms. Stady, do you care to make a statement here today to let me know anything that you wish for me to know?
Yes, Your Honor.
Okay,
Yeah, you're okay. Go ahead.
you may begin.
All right, Your Honor. First of all, I would like to apologize to the court and to this community for my actions. I know that drinking and driving is wrong, and I should not have tried driving to my friend's cabin after participating in the polar plunge. Second, I've done things in the last 12 years that I regret and that I'm not proud of.
I'm sorry.
I'm sorry.
You're reading, and so
Okay.
I just need
Yes.
to ask you to just read slower so my court reporter can take it down.
Okay.
Because this is a prison sentence, and as a prison sentence, she must do a transcript, okay?
Okay.
So I want to hear everything
Okay.
from you.
Okay. I'll restart.
Okay.
Your Honor, first of all, I would like to apologize to the court in this community for my actions. I know drinking and driving is wrong, and I should not have tried driving to my friend's cabin after participating in the polar plunge. Second, I have done things in the last 12 years that I regret and that I'm not proud of, like staying with my son's dad longer than I should have, leaving the architecture engineering firm I was working at to go to a general contractor. My biggest regret is being selfish and getting pulled over for an OWI and siren.
So, I gotta say something about that. I think it shows that a tiger never changes her stripes. She may volunteer 8 days a week. She may be campaigning for sainthood next year. We don't know. But we do know that she regrets getting pulled over in Siren, Wisconsin. Not driving drunk with the 269 through Siren, no. She regrets getting caught.
I obviously was not thinking about how drinking and driving would affect my son at the time. And now my significant other and our 9-month-old daughter. Let alone if I were to hurt somebody else or myself, and I thank the Lord that never happened. I've also done things in the last 12 years that I am proud of, and that has made me into the person I am today. I have a wonderful family, and I am so thankful for Mike Benjamin, who is not related to any of the Benjamins around here, no offense.
Please slow down.
Yes. Who is taking care of my 7-year-old son, Quinn, like Quinn is his own, and our 9-month-old daughter, Livy. We have become great friends with our pastor and his wife, who live 2 houses down. Quinn and their kids love playing together. We started going to Bible study on Thursdays with a group of women who are amazing this past summer. In 2020, I went back to college while working full-time and received my Bachelor of Science in Project Management in less than 2.5 years, testing out of 13 different classes. And at the end of 2020, I got my sole proprietorship for a commercial cleaning company, Reliable Clean Rochester, specializing only in post-construction cleans. I volunteer through work and on my own at multiple different organizations: Adopt a Highway, Ronald McDonald House, American Cancer Society, Hope Lodge, and I've participated in the polar plunge the last 3 years. I coached my son's t-ball team 2 out of the last 3 years. And I love volunteering for school field trips or events because I did not have that growing up. I've worked in the construction industry for almost 9 years and was a part of the interview process and team put together for the biggest Rochester Public School referendum in history and worked closely with the school district. I also have worked closely with Mayo Clinic construction managers since 2018 and worked on projects including the pharmacy addition, underground pedestrian and utility tunnel, Stevens 4th floor, in a 4-year project replacing 4 400,000-pound boilers in Franklin Heating Station. That will never happen again in this lifetime. I've also brought my son to a project every year for the last 3 years at the end of the school year so he can see how hard work pays off and see something getting built in real life. I do have a problem with drinking, and when I was in Rochester, I did a chemical dependency evaluation.
Again, I have to ask you to slow down.
Sorry. All right.
Everybody does it.
Yeah.
Read slower than you think you should
Okay.
have to.
I did a chemical dependency evaluation recommending the long-term 13-month teen challenge program. I know Wisconsin has different laws than Minnesota, but this program would not only benefit me, but the community and my family. And I do have a copy of each of the evaluations and the acceptance letter. We all make mistakes and hopefully grow and learn from them. I was young, Your Honor, with no direction from either of my parents. People accept the science of the medical field, but do not accept the science behind the criminal justice system in which people do change. Try to learn things the hard way and by myself. This isn't a common thing anymore. And I have a good support system that I have back home. I don't want this to sound bad or for you to take this the wrong way, Judge Mogen. But if this law came into effect to send to prison 6 years ago, I wish we could look at what I've done in the last 6 years and not from the last 12 to 15 years. I do respect the court's decision and I'm ready to deal with the consequences from my actions. Know that God has a reason for everything. And maybe this is just a part of my story. Yes, Your Honor.
All right, thank you.
Thank you.
Ms. Stady, I do appreciate all that you have said. That was a very thought out and very thorough statement. And it did give me a good look into your life and your rehabilitation after this incident occurred and what you have been doing. In sentencing, a judge has to look at certain factors, certain things. I have to look at first the nature and the gravity of the offense. How serious is this matter? Then I have to look at your character. I have to look at your prior criminal record and other factors about you. And then I have to look at needing to protect the public. All right. But I also have other things that I have to focus on and look at. If there are any victims, whether or not you have rehabilitative needs, I have to look at any undesirable behavior patterns. How culpable are you, your age, your history. I also have to look at deterrence, okay? Not only specific deterrence, deterring you from committing crimes like this again, but general deterrence from having others see that this won't be allowed and permitted, okay? Deterrence.
Yes.
That's part of what my job is, not only to punish the individual in front of me, but to look and see if there are ways to rehabilitate, because that's the goal. The goal is to rehabilitate so that you won't commit further crimes, especially this type of crime, but also so others won't as well. Now, this is a very serious crime. No doubt about it. Very serious crime. OWI 5. And I believe it's a 0.269 OWI 5. Very serious crime. And my higher courts tell me that I'm to give no more confinement than is necessary to meet the general sentencing requirements and the factors. All right. So I have to look at all of the factors and determine what would be an appropriate sentence. I can't look at this and go, this is a maximum possible penalty. OW5s are serious and it's the maximum penalty that I'm going to sentence you to. I have to look at all of the things and weigh those factors. And that's essentially how a court comes up with a length of a sentence. Okay. And here it's a prison sentence. Again, we have you highly intoxicated, 0.269, which is highly intoxicated, operating a motor vehicle on a highway or roadway of a county, which could put not only yourself at danger and risk of injury or death, but it puts others at risk of injury or death. I don't know how many times I hear of accidents of people involved in OWI accidents that cause death. It's, I don't want to say daily, but around here, you hear it all the time, a lot of the time. And it's scary. It's extremely scary. And that's why this is a very serious matter. I heard the arguments from the state and I heard the arguments from your attorney, and I listened very carefully to Ms. Donaldson. Ms. Stady, from the very beginning, I'm going to tell you, the very beginning, you wanted to take responsibility and you wanted to be accountable. I'm going to tell you that from the very beginning, you did. And then we had, I'll just call it a hiccup, where I didn't know, because you didn't let me know, that you gave birth to a child and you didn't want to leave that child. I was in the dark. I'll tell you what came across my mind is that you changed your mind. You knew this was prison and you didn't want to go. And that's essentially what it was. But I didn't know, A, you were pregnant. I didn't know that you gave birth in May. All I knew is that you were evading responsibility. You were evading my case and essentially fleeing, not coming to court. And you had a significant amount of money posted, $4,000. That is a lot of money. And that's already been long gone forfeited. Can't get it back. It's gone. That money should have been enough to assure your appearance for court, because that's a lot of money. For a single mom who's raising 2 children, that's a lot of money. But it wasn't enough to assure your appearance. It wasn't enough for you to contact your attorney and let him know what's going on, or contact the court and let me know what was going on. It wasn't enough. And then I don't know how it came about that you are now in custody. I think your attorney said you were a law enforcement officer in your state, came and knew that you had a warrant in Burnett County in Minnesota. They knew that you had a warrant here in Burnett County, Wisconsin, and they arrested you and brought you here. You didn't turn yourself in. And you're shaking your head up and down that that's not the case. You didn't turn yourself in. So again, to me, that's absconding. That's evading the responsibility. Once you were in custody, once you were back in custody, the Sarah Stady from the beginning came back. And you stated, again, I want to be responsible. I want to be accountable. I want to have my plea and sentencing. And you didn't even have your attorney at that time. You were prepared to even move forward without an attorney because you were ready to be accountable for your actions when you were back in custody. That does tell a lot about of your character. But again, you had to be in custody for that to occur. You have done a lot with your life in that amount of time, and you have done a lot for other lives in that amount of time since your OWI of March 4th, 2023. You have. I've heard it. You are a good person. You are a good mom. I have no doubt about that. And I'm going to tell you, I feel for you. I feel for you that you have been away from your babies for 77 days. I feel for you that you are going to prison. It's mandatory. I cannot, as a judge, this is not an emotional process. I cannot, as a judge, sentence somebody because I feel. I have to look at all of the factors and all of the things. And with all of the factors and all of the things, and even though you've done a lot in your life, I agree with Mr. Chapman. The community would definitely benefit if you were not in custody, because it sounds like you are building a really good relationship with a lot of people and a lot of entities where you can help a lot more people and you can continue to help yourself. I agree with that. And I would love to know as well as Ms. Donaldson, that triggering event, what happened? Something happened. Something did. Maybe you are emotionally aware of what happened. Maybe you're not aware because it's pushed way down. I'm not certain, and I'm not going to make you tell me. So the community would definitely benefit from you out of custody. But I cannot find that the community won't be harmed because I have to look at deterrence. And to me, that's very important. And here it's not necessarily directed completely at you to specifically deter you from committing this again, because I'm going to tell you, I think you've learned your lesson. You do not want to be away from your babies again. This is tearing your heart out. It is killing you. But I have to look at general deterrence. I have to look at the community. And if I do this once, then people will expect me to do it again. I'm not the legislature. I did not write the law. I did not determine that mandatory minimum, but it's there. And it's there for a reason, because these are serious. So as it relates to count one, the OWI 5, I'm going to sentence you to 1.5 years of incarceration and 1 year of extended supervision. And that is very low for extended supervision. I would have normally done 5 years. But I believe in the argument by the state, and I believe the statements made by Ms. Donaldson, and I believe your statements as well. And I think you're going to get your life back together. I think you're going to do the things that you need to do. And I don't think you need more than 1 year to do it. And I think, especially if you're going to look at Teen Challenge, which is an amazing program. It's an amazing program. If you're going to look at that, or you're going to look at other treatments, you're not going to need anything longer than 1 year. In my calculation of fines and fees, I come up with $4,412. That does include the $10 blood draw fee. So $4,412 total. The court has ordered that all of the costs and fees are to be collected as a percentage determined by the Department of Corrections to be reasonable while in state prison and as a condition of your extended supervision. The Department of Corrections shall collect these sums. They'll collect it from you. And at minimum, when you are released, at minimum, $100 a month. Okay?
Yes.
And that can be reviewed later. If I, well, and I'm going to tell you, here's the deal. Once you were released from prison, and if you come back to me, and Ms. Donaldson is hearing this, and you want to do community service, I will waive as much of that as I can. Okay? Which could be thousands of dollars. Because I believe that you will do that. I believe from hearing from Ms. Donaldson and hearing from you, you will do that, and you will put, because you already are. Okay? So Ms. Donaldson, please remember that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose your right. You're pleading guilty to a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you, but I will issue a warrant, and you could sit up to 6 months in jail. You see how that goes. I need your DNA. The jail will make sure that they have it. I'm not certain if this is a charge that you can have your DNA expunged, but you can attempt to do so by a written letter to the Department of Justice, not to the court, to the Wisconsin Department of Justice. 77 days of jail credit. I believe I've covered everything, but am I missing something, Mr. Schmidt?
Not that I've noticed.
Mr. Chapman?
I think you have to make a finding of eligibility for earned release
Oh.
program and challenge incarceration. She's not eligible to be released early, and I'm guessing that they won't even put her in it because she can't get out early, but I'd ask the court to find her statutorily eligible.
I find her statutorily eligible on extended supervision only.
Oh, if revoked is what
If
you're saying?
revoked,
I see what you're saying.
yes. If you're revoked off of probation, you would be eligible for the challenge incarceration program and the substance abuse program, but not while in prison, because this is a mandatory minimum sentence, okay?
Yes.
All right. Thank you, Mr. Chapman, for reminding me about that. We are adjourned.
Thank you, Judge.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me, and let me know what you'd like to see and how I can improve. Thanks.